Hello, my name is John Flood. I'm the owner and managing attorney of Toolkitlaw PLLC. Toolkitlaw practices exclusively in family law. So I do divorce, child custody, child custody modifications, child support modifications, establishment of paternity, terminations and adoptions, property division, and so on and so forth. Um, the Flood Law is based in Tomball, Texas, and serves Harris County, Montgomery County, and Brazos County primarily. I've also done some practice in Fort Bend County, Galveston County, and then some of the other smaller counties, Madison County, Grimes County, and I've done some work as well over in Travis County, Williamson County, and Hayes County. So I've practiced in quite a few different courts. I've had at this point in my career, hundreds of evidentiary hearings from bench and jury trials to temporary orders hearings to CPS hearings to other types of oral evidentiary hearings, such as a plea to the jurisdiction. So I've done a lot of trial work, if you want to call it that. I've had a lot of hearings where evidence had to be introduced, where witnesses had to be examined in order for the judge to make a decision. And what I'm going to talk about today is direct and cross-examination of witnesses. And the information and the principles that I'm discussing today, these are things that I've gleaned from many years of being in the courtroom and seeing how evidentiary hearings and evidentiary rulings and these sort of things play out. And so I've tried to keep it as practical as possible because a lot of, sometimes the way things are in the rules or the way things happen, you think that they would happen, or in theory, they can happen differently in the courtroom. And of course, that depends on the courtroom and the judge and your opposing counsel and all sorts of things. But I've tried to keep these principles and this information as practical as possible. And I'll offer some along the way. I will offer some um, examples and insights from my own personal practice and in cases uh, that I've actually done. So with that, we're going to jump into it. This is divided into two parts. We're first going to talk about direct examination of witnesses, and then we're going to talk about cross-examination of witnesses. This piece of the course will be about 30 minutes. So the goal is to spend around 15 minutes talking about direct examination and then around 15 minutes discussing cross-examination. You've been provided a help sheet to go along with this course. And so I'm going to use the help sheet as I go through the content as a springboard for the content. So I'm going to go ahead and share my screen, and let's pull up the help sheet, and we will go through these things. So in an evidentiary hearing, a bulk of your evidence is normally going to come through the examination of witnesses. And this is going to be direct and cross-examination. Now, when we talk about direct examination, we're talking about examining witnesses that are favorable to you, that are favorable to your position, that are favorable to your side. So of course, that's going to be your client, but then that can also be other supporting witnesses, and including friends, relatives, or family members. It can also at times include professionals such as a counselor or a CPS caseworker or someone who has been subpoenaed to come in, who is a non-party, unrelated professional. You can be doing direct examination of them as well if they are a supporting witness. And then, of course, experts as well. And so all of this falls under the category of direct examination. So the first thing that I want to point out that's very important, and I think is oftentimes I've seen, in my opinion, overlooked, is preparing your witnesses. Preparing your witnesses. And I think this is especially crucial on direct examination because, as I'm sure you know, you can't, or you're not supposed to ask leading questions to your direct examination witnesses. So if it's a hostile witness or someone the opposing counsel's called on their side, as we'll talk about in a minute, you can ask leading questions. So you can suggest the answer in the question. You can't do that in a direct examination. So that makes it more difficult because you can't give them the answers right in the questions. You're supposed to ask open-ended questions to try to elicit the information from them. And for anyone who's done it, um, especially in a courtroom, whenever the witness is under oath and nervous, that can actually be very difficult. The witnesses forget things, they don't understand really what you're asking for. They answer questions sometimes in bizarre ways or provide, unhelpful information. And it can be very difficult if you have an opposing counsel who's objecting to leading, and a judge who's strict on that. It can be very difficult to actually get the facts and the information that you need out from that witness, using open-ended questions. So it's something that to help cut down on that and to help make sure that you get the information that you're looking for from that witness, you prepare that witness beforehand. You prepare with them beforehand. And you can do that with all of your witnesses. So if you have obviously you do that with your client, but you can also do that with family members and even with professionals and third party witnesses that you're planning to call. You can call them beforehand, talk with them, get an understanding of what they know and what they don't know, give them an understanding of the kind of questions that you plan to ask so that they're prepared. And everyone kind of understands what's important, what facts need to get out for the judge to hear, and everyone feels calmer, more confident, and can be more consistent and credible when they're testifying. This can be called woodshedding, when you woodshed a client or a favorable witness. And you have to be careful with how you do this as an attorney because there are ethical considerations here. Of course, you cannot tell a witness uh, to change the facts or to lie or to make anything up. That's obviously off the table. You can help witnesses structure their answers, but you really need to be careful about, of course, feeding them facts or even directly telling them what to say. It's a delicate situation whenever you're woodshedding, but you definitely can help them. You can work through the questions with them, ask them the questions, go through their answers, and you can help them come up with uh, you know, cleaner answers, and also making them aware of the kind of things that are objectionable, such as hearsay, because clients will often want to get into hearsay or they'll want to get into things that aren't relevant to that particular question or even to that particular the issues before the court. So you can help them avoid those sort of pitfalls so that they're not taken off guard in court, and you can help them with their responses to the questions. And along those lines, that leads to the second major point, which is you should create question scripts. You should create question scripts. Now, there are different ways to do this. Some attorneys will script every single question and do very detailed question scripts. I tend to do that. Okay. Other attorneys tend to be lighter on the question scripts and they have maybe major headings, perhaps subheadings, and then bullet points with information, but they don't actually script all of their questions. And then some attorneys, from what I've seen, do little in the way of question scripts and sometimes nothing. Now, I will tell you a few times in my practice, I've had attorneys comment on creating question scripts and act as if they don't need to do it, that they've been doing this long enough that they don't need to create a question script. They don't need a script. They know what they need to ask. But then when you listen to that witness, that lawyer's direct examination, it's disorganized. It doesn't flow well. Their witness is confused or doesn't answer questions, and you can tell in the way that they're looking for, and they run into objectionable questions. So, in my opinion, no matter how long you've been practicing, it's good to script your questions at some level. The other advantage of this is it plays into the first point, which is if you create a question script for a witness, you can send that question script to the witness and allow them to look it over before the hearing so they can see the questions that you're going to ask, or roundabout what you're going to ask uh, in the hearing, and they can think through their answers and feel like they know kind of where things are going, what questions are going to be presented with before they get to court. And that can help them, again, feel more confident and more calm. It can help alleviate their nerves and the nervousness with testifying when they feel like they have a sense of what's coming and they're prepared. So that's the other advantage to creating a question script. In addition to helping the lawyer, it helps the client. So some tips for an effective script: tailor each script to the witness's knowledge, experience, and communication style. So likely your firm is going to have some standard templates or some question scripts you've used in the past, some generic go-bys. You want to take time to tailor that script to each witness, because each witness, of course, in each case, they're going to be unique facts, unique events that have occurred, and that witness is going to have unique facts or a unique perspective that needs to come out. And a lot of times that can only come out by specific questions. So you can often use some generic questions that roll over from one script to another, but you want to tailor the script to some degree to that particular case and to that particular witness. Simplifying your language and your questions is important. As lawyers, we can sometimes we use legalese, or sometimes we use big words, and also we have a habit at times of asking lengthy, confusing questions. So working on simplifying your language in your scripts and in your questions, and then simplifying the questions so that you're not asking a question that confuses the witness. And then revising and updating your script as you get closer to a hearing, especially in family law. Facts are always developing, things are always happening. It's not like a personal injury case where you had an accident that occurred at a certain point of time and you have a set event and set of facts that occurred. With family law, things are continuing to happen and continuing to develop right up to the time that you walk into the courtroom. And so keeping that script up to date is a good practice. And then, as I hinted at earlier, sending that script, that completed script, to your witness or to your client 24 to 48 hours in advance, so they have time to review the questions that you're going to be asking. This is a good thing to do. All right, anticipating objections. This is something that you want to do both in your scripting and in the incorporation of your exhibits. When you're incorporating exhibits, you want to be thinking about what objections you're going to get to your questions, to your exhibits, to your evidence. Right off the bat, as we talked about in your examination, your direct examination, you have to be asking non-leading questions. Non-leading questions. Okay, so a leading question is a question that suggests the answer in the question. And a non-leading answer is an open-ended question. These are going to be questions like who, what, when, where, why, how. Questions that start with these words. The most common type of objections you'll see in court are going to be leading, hearsay, relevance, a lack of foundation or predicate, and speculation. In my experience, these are the 5 most common objections you're actually going to hear in the courtroom. And so thinking through all of these objections as you script each question, and then as you prepare your exhibits, is a good thing to do. At times, you're going to offer an exhibit that is objectionable, or the opposing counsel is not going to make it easy for you. And so by anticipating the objections, you should be thinking through when you're doing that, going through that process, you should be thinking about your responses. And if you need to, going to the rules of evidence, pulling particular rules and being prepared to argue those rules in terms of why the question is appropriate or the testimony is appropriate or the exhibit should be admitted, that sort of thing. Next is having a theme and a story that you're telling. Human beings naturally place facts and events within an interpretive framework. So they don't, when a judge is listening or to your case or a jury is listening to your case, they're seeking to take the events and the facts that are being that the witnesses are, detailing or the exhibits are showing, and they're trying to put them together in their mind in something that makes sense, some sort of mental framework, or more often a story of what happened in their mind. And so, knowing that, you should frame your case as a story. As you're examining witnesses, both direct and cross, you should be telling a story. And of course, you use your opening statement and your closing argument to really to both give them the framework of the story at the beginning, to give them your theme or your story. And then at the end, you argue, and again, you're telling your story through the argument of evidence and what they've seen. So you should be telling a story, and you should have some major themes. Two quick examples. I was representing a father in a termination CPS case, termination jury trial, where the department was seeking to terminate his rights. We had a lot of bad facts on our side of the case. Lots of bad facts. It was not looking good for us. I knew, based on the circumstances, my client, it was not reasonable to expect that we could be a managing conservator. We were not going to be a conservator, but we could fight against the termination and perhaps keep the jury from terminating my father, the father's rights. And so what we did was we created a story. My client really liked basketball. So we created a story about a young man in high school who's not very good at basketball, but he's trying to make the team and trying really hard. And the uh, coach calls him in and says, "Hey, I'm going to cut. I've got to cut one more person. It's between you and another guy. Tell me why I should keep you on the team." And the player says, "I know I'm not very good, coach. I have a lot to learn. I'm still practicing. I realize that, and I know I'm not going to be a starter. I'm fine sitting on the bench. I just want to be a part of the team. I'll contribute in any way I can. I just want to stay on the team, coach. Just be a part of the team." And that sort of thing. And so that was the story that we used that we in that case was we knew that he was going to be sitting on the bench, that he wasn't going to be a conservator, but he still had value. He still could stay on the team and still contribute value to his children's lives. In another case, at a custody case, is a custody modification case, and there was a lot of history here. The previous order had been entered 10 years ago, so there were 10 years of facts that we were dealing with, and just a ton, as you can imagine, a ton of facts, a ton of events, and a lot of things that occurred in 10 years. And so what I did with my client and for the judge was really created four themes that sort of arose from the facts that we pushed home throughout the examinations. And that was alienation, violence, drug use, and instability. And I had, I prepared my client such that she understood that those were our themes and would use those words throughout the course of her direct examination. And so that's what you should do. You should be doing something like that in your examinations, incorporating exhibits. You should most of the time, or a lot of times, you're going to have some sort of documents that support your witness's testimony, making sure that those are properly marked, they comply with evidentiary rules, anticipating any objections, and then moving forward and being ready to offer those at trial. With your exhibits, less is more, in my opinion. I can't tell you how many times I've seen a lawyer, myself included, I've done it. You walk into a temporary orders hearing or a trial with 30 exhibits or 50 exhibits, and you end up using 10 of them. And so the longer that I've practiced, the more that I've gotten leaner on my exhibits. And so you should really think about, do I actually need this? Do I actually need this exhibit? Am I actually going to use this? Are there any redundancies here? If you're in a temporary orders hearing and you have an hour and a half, you have to realize you're not going to be able to use 30 exhibits. And so keeping it simple and cutting down on the number of exhibits you have can be very helpful. So these are all principles related to uh, direct examination. Okay, with that, let's move into cross-examination. So we have about, I went a little over, I think, on the direct examination, so I'm going to try to do this in about 10 to 12 minutes to keep this at a 30-minute course. So with cross-examination, we're talking about examining hostile witnesses. So this is going to be an opposing party. This is going to be an opposing expert. And this can be any witness really that's hostile to your side or to your position. And whenever that's the case, you're in cross-examination mode. And with cross-examination mode, in cross-examination, you can use leading questions, and you should use leading questions. Unlike direct examination, leading questions help you maintain, on cross-examination, you should use them, and they help you maintain control of the witness and the flow of information. On cross-examination, you should keep tight control of that witness, of what that witness is testifying to. Most of the time, when you're cross-examining a witness, it's actually not their answer that's really all that important. It's your question. Your question is what contains the information that you want the court to hear. And I had a partner of mine and a good trial lawyer tell me very early on, I don't care how a hostile witness answers my question. I don't care. I hardly even listen to their yes or no answers. It doesn't matter. What's important is the question I'm asking and the information that's in the question. And you don't want to give a hostile witness a chance to explain themselves by asking open-ended questions. For the most part, that's not something you want to do with a hostile witness. You want to ask leading questions that keep them boxed in with yes or no answers, and opposing party, it's up to them to clean that up or to ask the open-ended questions that give the witness a chance to explain. That's not your role when you're cross-examining a witness, to give them the chance to explain. That's not your role. Your role is to keep telling your story, to keep advocating for your client, and to cross-examine that witness. And along these lines, do not be afraid to use the objection non-responsive. So if a witness attempts to answer any of your leading questions with anything but yes or no, you should object to non-responsive. That's how you control that witnesses. Some witnesses, it will take 4 or 5 times of them being shut down like that before they'll stop. But I really, for the most part, I haven't seen a witness go beyond 4, 5, 6 times of doing that, where they kind of get the point and they submit to just yes or no or very short answers, rather than trying to give long explanations or answers to questions that haven't been asked. So use that non-responsive, and often judges will play ball with you on this. They will allow you to control that witness's testimony with non-responsive objections. It depends on the judge, but most judges, from what I've seen, they will sustain non-responsive objections. If you ask a yes or no question and the witness tries to go off on a long explanation or a narrative or anything like that, a court will shut that down. So use that objection to control the hostile witnesses. Secondly, keep telling your story. Just because you're cross-examining a witness or it's their case in chief, you don't stop telling your story. You keep telling your story. You keep pounding away at your themes. Now you're just doing it on cross-examination through the witnesses. And it's primarily your questions that continue to tell the story, or the exhibits that continue to tell the story. But you definitely want to keep telling your story as you're doing cross-examination. The next point is impeaching a witness. So in addition to attacking the facts as they're being portrayed by the opposing party, you can also attack the character of the witness, the credibility of the witness. And you do this in order to undermine or weaken the impact of their testimony. So there's only so much you can do about what they're going to say. They're going to have their interpretation of the events, of the facts, things that they've seen that are going to be unfavorable to you. And there's only so much you can do about that. You can call their perception of events, their facts into question, or show that there's conflicting evidence on the other side and things. But the other thing you can do is attempt to show that the judge just should not give much weight to their testimony. And that you do through impeachment. So you want to try to highlight, when you're crossing examining a witness, you want to try to highlight inconsistencies in their story. You want to try to highlight bias and credibility issues. And there are different impeachment categories. As I mentioned, you've got bias, interest, or motive. You've got prior inconsistent statements. So if they've made statements inconsistent with the statements they're making in court, introducing those statements, asking question about those statements, bringing those statements to the court's attention can undermine their credibility. You can question their perception, their lack of perception, or their personal knowledge. So a lot of times you can do in family law cases, you can box the client in terms of their personal knowledge. So if you have a friend who's testifying on behalf of the other party and they testify to some things about your client, then you can seek to show that they haven't seen your client in 2 years. They've never been to your client's new home. They haven't seen your client interacting with the child in X number of years. They've had very limited contact with your client. And all of that potentially as to the other side as well. And so challenging their personal knowledge, or the lack of personal knowledge, can be an important impeachment technique. Introducing contradictory evidence, and then you can have a character for untruthfulness, that they lied or they have lied, and then prior criminal convictions. These are all ways that you can impeach a witness and attack their credibility. Kind of along the lines of what we discussed at the very beginning of this section on cross-examination, you have to know when to stop. The questions that you don't ask when you're cross-examining a witness are as important as the questions you do ask. Numerous times, and I've done it myself, I've seen lawyers step into answers from a hostile witness that they didn't want, where their question elicited unfavorable facts from that witness. And sometimes it's facts that had not come out in the direct examination by the other party. So you have to be very careful when you're on cross-examination about the questions you ask. And it's important to understand that sometimes, many times on cross-examinations, it's what doesn't get said, what doesn't get testified to, the evidence that isn't there is as important as the evidence that is there. So with each witness that you cross-examine, you want to think about your objectives. What are you trying to get out of this witness? What are you trying to show through this witness? Meet those objectives and then stop. Look for chances to get concessions. So if the witness agrees to a critical point that supports your case, consider passing the witness at that point. Normally, there'll be some back and forth. So you can pass a witness, it'll go back for direct, and then you can take that witness up again on recross. So just because you stop doesn't mean your examination is over. That just might be a good stopping point at that moment to kind of let that resonate with the judge. Give a little pause, let that sit there, let that silence, let that answer sit in that silence for a few minutes, or not a few minutes, but a few seconds, and then pass that witness. That can be an effective technique. And then reading the room. If you start to see a judge or jury's body language indicate that they're getting frustrated or irritated or losing interest, it's probably time to wrap up. Okay. You can also get an indication of this if you start seeing an opposing counsel object to relevance or asked and answered, or they start pitching up a lot of objections, and the court is sustaining those objections. That's normally a good indication that the judge has heard enough from this witness and you need to move on. Lastly, on cross-examination, be respectful but firm. So no matter what the witness says or does, always try to maintain a professional and calm demeanor. If you've done trial work very much at all, we've all seen the lawyers who uh, aren't very professional, or who are overly aggressive and come off as very angry, aggressive, combative. And there's a time and a place for, being combative and aggressive with a witness, but for the most part, you need to maintain, or you should maintain, a calm demeanor no matter what the witness does. And the more aggressive and angry and combative the witness gets, if you remain calm, that creates a contrast between you and the witness and can make the witness look unreasonable. And this can help you win the respect of the judge, the jury, and sometimes even the witness themselves. I've had judges comment to me and to opposing counsel afterwards, thanking us for, being professional. They, just recently, in fact, at a bench trial, after the judge commented that she appreciated our professionalism, and there's so much unnecessary negativity in the court between attorneys and things, and she appreciated that we didn't engage in that. So, being respectful and maintaining a calm and professional demeanor can go a long way with judges and with fact finders. So, but at the same time, you also do need to be firm. You also do need to be firm. And depending on the witness, sometimes you need to get a little more aggressive and you need to get a little more firm. Um, And that kind of goes back to what I spoke to earlier about non-responsive objections, for example, where you raise your voice and start to speak over the witness. Objection non-responsive, because you've got to speak over them. Or objection hearsay, if they're about to say something that the child said and put that in the court's mind. So there are times when you do need to kind of raise your voice or be a little more aggressive with the witness and with the client. That happens. Just be professional and try not to get too carried away with that or let your emotion get the best of you. Okay, so that ends this course on direct and cross examination. I hope this has been helpful, and good luck to all of you in your trial work.